All right. Good afternoon, good morning for some of you, depending on where you're joining us from. I'm going to ask for a little grace. It's the first Wednesday of the month, and our tornado sirens are testing, and my dog is howling like a banshee downstairs. So I apologize if you hear any background noise. My name is Ryan Wyant. I am the CEO of the LGBTQ plus Real Estate Alliance. The Alliance is one of the partner founding organizations of the Stop Hate in Real Estate initiative and campaign. And we are proud to be along our sister organizations in ARIA, NAREP, and Women Up, a subsidiary of California Association of Realtors. We've joined forces to take on hate and discrimination in our industry. And the Stop Hate in Real Estate initiative is simple, folks. It comes down to the golden rule. Do unto others as you would have them do unto you. We believe it's time to stop hate. It's time to stop the excuses that we hear time after time in rationalizing hate and discrimination in our industry. And that change starts with you. So we encourage everyone to go to stophateandrealestate.org and sign the pledge. Check it out. We have thousands of folks around the country who have already signed on, many corporations and partner organizations who have taken the pledge as a corporate entity. And really, it's a movement and it's spreading, and we're not going to let it go anywhere. Today's session is extremely exciting. Many of you over the last several years have had a ton of questions about the National Association of Realtors Code of Ethics and the professional standards amendments in that code that govern a lot of our members. We have taken time today, and we have the benefit of being with one of my good friends and someone I've respected for a very long time, Mark Mansour, who is one of the original founders of these code initiatives and really the hearing process. Mark is a total whiz when it comes to this, and he has served the realtor community throughout the East Coast and really on a national level at NAR in just about every elected position possible over the past decade. Too many for me to go through today. He's taught classes throughout the country and has taught over 11,000 realtors in some capacity. Mark has served on many National Association of Realtors committees, including the Board of Directors, Professional Standards, RPIC, and NAR's Broker Involvement Committee. Mark notably served on the Professional Standards Committee and has been vice chair and chair of the Professional Standards Committee in 2020 and 2021, and chair of the 22 Professional Standards Interpretation and Procedures Advisory Board. So when we say Mark wrote the book on this, he's literally one of the 3 or 4 folks who did write the book on this. So I could ramble on, but you're not here to see me. Please stick around for the next hour. I promise that you're going to be educated. You're going to find what Mark has to say valuable, and hopefully it helps you navigate your own internal process with the governance system at NAR. So without further ado, Mark, I'd like to bring you on screen and welcome you to the session today, and I will turn things over to you.
Okay, thank you, Ryan. That was too kind. There were many members, participants, NAR leadership team, executive committee that made this happen in 2020. I appreciate, Ryan, you saying I was one of the few, but there's a lot I can't even imagine to name. I do know my chair at the time was Matt DeFonis from Champaign, Illinois. And so I was fortunate to be at that right time, at the right place. So many people to thank. I do want to start by, I do not have access to the chat, but I did notice that Ruben from Texas mentioned the Texas Rangers. I do want to tell you, Ruben, I've lived and was born from 55 years in West Virginia, but I am a huge Texas Rangers fan. Have been for 30 years. So yes, I was very excited they won the World Series. Now, let's get down to business on what we are going to talk about. We're going to talk about the rationale. We're going to talk about the history of the Code of Ethics as far as the history of Article 10. Then we're going to drill down on the Standard of Practice 10.5 and the rationale on how to to determine or have the knowledge to know if that is hate speech, an epithet, a slur. So I want to start with the slideshow as far as the history. A lot of you may not know, a lot of you may know, but back in 1924, there was an article in the Code of Ethics, Article 34, that stated a realtor shall never be instrumental in introducing into a neighborhood a character of property or occupancy, members of any race or nationality or any individual whose presence will clearly be detrimental to property values in that neighborhood. That was in our code. That was Article 34 of our code in 1924. As we moved on, Article 10 was created in 1974. Article 10 stated at that time in 1974, the realtor shall not deny equal professional services to any person for reasons of race, creed, sex, or country of national origin. A realtor shall not be a party to a plan. Very important second sentence. A realtor shall not be a party to a plan or agreement to discriminate against a person or persons on the basis of race, creed, sex, or country of national origin. Then in 1989, Article 10 was amended to add additional protected classes. It did take out the word creed. It now states in 1989, the realtor shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, or country of national origin. And those classes were added to the important second sentence. In 2000, we were even ahead of the federal government in employment practices by adding the second paragraph, not the second sentence, but the second paragraph that state realtors in their employment practices shall not discriminate against any person or persons on the basis of race, color, religion, sex, handicap, familial status, or national origin. And then in 2011, sexual orientation was added to the Code of Ethics. I actually was there in 2010 and sat on the Professional Standards Committee when sexual orientation was brought to the committee and was adopted. And it hit the Code of Ethics January 1 in 2011. And then in 2014, gender identity was added to the Code of Ethics. And again, I don't think I was ever been off that committee, but in 2013, I was on the committee when gender identity was brought to the table, to the committee, and what is adopted and passed by the board of directors. And then January 1, 2014, it was added to our code. So let me go back. The Article 10 now states, as of, and will state January 1, 2024, realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex. We have changed the word handicap to disability, familial status, national origin, sexual orientation, or gender identity. The second sentence also states the same. The rationale as far as where and how the code adapts is, if anyone is familiar with the Code of Ethics, there is, before you even get to Article 1, there's a preamble. Now, the preamble to the Code of Ethics is the aspirational foundation of where the code and the articles came from. Some of the aspirational foundation of the Code of Ethics in the preamble, I just pulled a few of the paragraphs out. Realtors shall recognize that the interest of the nation and its citizens require the highest and best use of the land. The highest and best use of the land. Also, in the preamble, it states widely allocated ownership and widest distribution of land ownership. That doesn't mean we want the widest distribution of land ownership for this set of people, but we don't want this set of people to own land. So it was set in our preamble years ago. Also, where the enforcement comes in. They, realtors, identify and take steps through the enforcement of the Code of Ethics and by assisting appropriate regulatory bodies to eliminate practices. Eliminate practices which may damage the public or which might discredit or bring dishonor to the real estate profession. That is in the preamble, and that's huge. That's one of, I don't want to say one of my favorites, but this is when people say, why should I file a complaint? Oh, they're going to do it again. Here it is. If you have the ability to protect your profession, protect the public, and protect human beings, you as realtors have the Code of Ethics and the enforcement process. You have the responsibility to prevent this from happening. So that is, again, in the preamble, before the articles. That's when and what we used as part of the rationale for Standard of Practice 10.5. Now, just a real fast history. Of course, the National Association of Realtors was founded in 1908. Back then, it was called the National Association of Real Estate Exchanges. 5 years later, the Code of Ethics was adopted in 1913. 110 years today, 110 years this year in 2023, we have lived by a higher standard because we're realtors, because we live by the Code of Ethics. It has been amended many times. You saw back in 1924, the awful Article 34. It has been amended, has been changed, it's been deleted. So on October 5th in 2020, the National Association Professional Standards Committee met to consider recommendations from the Interpretations and Procedures Advisory Board on the Code of Ethics applicability to discriminatory speech and conduct. Now, I mean, we could talk all day, but I will let you know there is another committee, a smaller committee. I like to call it the committee of the smartest people I know, and I call myself a nerd. That meets. It's the Interpretations and Procedures and Advisory Board. They meet prior to the main committee, big committee meeting, and we listen and bring in requests from the public, from realtors, from local associations, from state associations on different issues, different problems. And so in 2020, we had this huge discriminatory hate speech, epithets, slurs on social media. It was realtors behaving badly. So the committee approved the advisory board's recommendation. So the full committee approved it. And then we went to the National Association Board of Directors at the November 13th, 2020 meeting. So what was adopted and effective on November 13th, 2020? Now, if you were listening, some of you heard that back in 2010, sexual orientation was brought to the table. It hit the Code of Ethics on January 1st, 2011. Any amendment, any change, any deletion, any addition that is approved that year will then be on printed January 1 of the next year for the Code of Ethics. That's when it goes into effect. This was adopted and effected the day of the board of directors once it passed on November 13th, 2020. It was so important, and what we were seeing as far as the I will say hundreds of hate speech on social media, the epithets, the slurs, that we felt it needed to be adopted and effective November 13th, 2020. So I cannot tell you the time. I think maybe 2 p.m. is when this was passed. And now Standard of Practice 10.5 states, under Article 10, realtors must not use harassing speech, hate speech, epithets, or slurs based on the protected classes according to Article 10, which are the 7 federal and the 2 Code of Ethics, sexual orientation, or gender identity. Now, the new Standard of Practice 10.5 flows from requirements to not deny equal professional services or be parties to plan to discriminate. It also flows from the preamble, exactly what we were talking about earlier in the earlier slides. Widest distribution of land ownership. Widest distribution of land ownership. Yes, we want many people to own land. And this is why we don't discriminate. We don't want certain these people to own land, but we don't want them to own land. The public posting of hate speech would reveal bias against protected classes. Public posting of hate speech could result in realtors not taking clients from certain protected classes or not treating clients equally, and such actions would violate the Fair Housing Act due to the overt discrimination or disparate impact. So this is how the Standard of Practice 10.5 came and the result of it. Now, a lot of you may be asking, okay, this is awesome. This is what we need. How do you understand, and how do we understand what is hate speech? What is harassment? What is epithets or slurs? First of all, step one. Is the speech harassing speech? Is it hate speech? Is it an epithet, or is it a slur? Step two. If step one is filled, step two. If so, is the speech based on the protected classes of Article 10 of the Code of Ethics? Again, race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. The application of Standard of Practice 10.5 when it comes to a possible violation, it is objective. It's not subjective. You need to have clear, strong, and convincing evidence is the burden of proof the complainant must provide. The complainant is the one filing the possible violation. Now, Standard of Practice 10.5 is harassing speech, hate speech, epithets, and slurs, primarily on social media platforms. The burden of proof is pretty strong when you have a tweet, when you have a Facebook post, when you have other social media platforms there that you could capture and keep. Okay. Context is scrutinized as with any allegation of violation of the code. So it is the objective, clear, strong, and convincing evidence, and the context is what most grievance committees and hearing panels will look at when a possible violation of Article 10, supported by Standard of Practice 10.5, is presented. Also, on November 13th, 2020, not only did the Professional Standards Committee bring to the Board of Directors, the National Board of Directors, the 10.5, Standard of Practice 10.5, but we also brought them the Statement of Professional Standards Policy number 29. And it used to state the applicability of the Code of Ethics to non-real estate related activities. While realtors are encouraged to follow the principles of the Code of Ethics in all of their activities, a realtor shall be subject to disciplinary action under the Code of Ethics only with respect to real estate related activities and transactions involving the realtor. And that was it. You could be charged with a violation of one of the articles of the Code of Ethics, or a violation could be charged against you with 29, the way it said, the policy statement 29 at the time. Now, I don't know about you, but all of us are realtors. I don't like to use the word part-time or full-time. You're a realtor. I don't think someone that may have another job pays part-time dues. I don't think that someone in the real estate industry runs around at 5 p.m. and takes all the magazines with their ads and hides them and then puts them back up at 9 a.m. the next morning. It is not a 9-to-5 job. You're a realtor 24/7. You cannot be a realtor from 9 to 5 and then go home and be a keyboard bigot. So policy statement 29 was changed. The applicability of the Code of Ethics. A realtor shall be subject to disciplinary action under the Code of Ethics with respect to all of their activities, period. So policy statement, professional standards policy statement number 29 was changed as well, November 13th, 2020. Now, there are some appropriate interpretations of the standard of practice 10.5 and the statement number 29. We did put it into Appendix 7 to Part 4 Code of Ethics of the Code of Ethics and Arbitration Manual, which is a pretty big book that most professional standards administrators, professional standards members that sit on committees have access to. So there was additional guidelines that would explain harassment, hate speech, epithets, and slurs. NAR's Code of Conduct and Anti-Harassment Policy states epithets, slurs, or negative stereotyping, threatening, intimidating, or hostile acts, denigrating jokes, and the display or circulation of written or graphic material that denigrates or shows hostility toward an individual or group based on a protected characteristic. So it 10.5 again is geared toward, and the reason was because of social media, but this also includes displays, circulations, denigrating jokes. I actually received a picture and a call from a realtor in California after this was passed, and he showed me what some of the fellow realtors in his office, who he no longer works there, put as a screensaver on the computer. And it was, again, geared toward the COVID incident and the Asian hate that we saw. So it doesn't have to be posted on a social media. It could be in the office. It could be a joke, a denigrating joke that shows hostility towards one of the protected classes. Now, context does matter. And the following statements are examples for discussion purposes only. They have not been evaluated. We have not evaluated them by the National Association as potential violations of Article 10. They are only examples for discussions that we have seen. Negative stereotyping, depicting on social media a picture of Kobe Bryant and his daughter with a statement. And this is what we saw. First Black man to leave and take his child with him. Again, the above statement is example for discussion purposes only. It has not been evaluated by the National Association as a potential violation. But this is showing you hostility toward an individual or group based on Article 10 protected classes. Hate speech in the book I just showed you is defined as speech that is intended to insult, offend, or intimidate a person because of some trait, race, religion, sexual orientation, national origin, or disability. Hate speech example. Again, these are statements of an example. Those, insert a religious group, are the scum of the earth. We should take every opportunity and any means available to drive them out of our community. Again, this is an example for discussion on hate speech. Epithet, the definition of an epithet. A characterizing word or phrase accompanying or occurring in a place of the name of a person or thing, a disparaging or abusive word or phrase. For example, and you put an epithet relating to national origin, is disgraceful. Just look at those clothes. Go back to where you came from. A slur definition is insulting or disparaging remark or innuendo, aspersion, shaming or degrading effect, a stain, a stigma. Example, that reference to a sexual orientation or gender identity is not welcome in our neighborhood. Those people are perverted. Now, standard of practice 10.5 and all the other changes, like I stated, apply only to conduct that occurs November 13th, 2020 and thereafter. We cannot go to November 12th, 2020 and say, well, I saw this on November 12th. 10.5 was effective and adopted November 13th. There is no going back. So everything from November 13th, 2020 forward is now a possible violation of Article 10. Public trust issues also involving real estate are referred to licensing authorities. So enforcement of the code also requires member boards to share with the real estate licensing authority final ethics decision holding realtors in violation of the code in instances involving a real estate activities and transaction where there is reason to believe the public trust may have been violated. Again, this could be anything from fraud, deception, fair housing. Definition of public trust. The public trust is used in this context refers to demonstrated misappropriation of client or customer funds or property. We took out the word willful discrimination against the protected classes under the Code of Ethics or fraud. So this is our Article 4, Section 2 of the National Association bylaws. We revised them as well on November 13th to have the definition of public trust changed. Now, the hearing panel is privy to all facts and circumstances taken into consideration the entire course of events, weighing a respondent's experience, prior violations, and mitigating or extenuating circumstances. So when and if someone may be found guilty of a violation, and we're going to talk a little bit about the process because you need to know, and there is some question on how do I file, who do I file with. But if the sanctioning guidelines state that if you all would find me guilty of a violation of the Code of Ethics, they also would ask after the respondent was found guilty, they will then go back to the governing board, whether it be the local association and or the state association, whoever runs the professional standards, and say, has Mark had prior violations? They do not know that during the hearing, but after they have made a decision, they will then ask the governing board, has he violated something in the past, which would weigh in on the sanctioning if he is found guilty. Ryan, any questions so far that we need to talk, or should we move on?
You know what, Mark? We do have a couple of questions, and it's probably timely before we get too far down the road. Our friend Chuck Wells wants to know, Mark, was the standards policy number 29 revision only applicable to 10.5 or all ethics articles and standards of practices?
All ethics articles and standards of practices.
Fabulous. Appreciate that. And then one question coming from our friend Patrick Harrison. I realize this is a little bit more complex, Mark. This might be a dialogue for you and I to have at the end, but I'll put it on your radar now. How do we combat code of ethics violations with regards to RPAC? I'm specifically referring to contributing to the campaigns or people who do not embrace our code of ethics. Do you want to try and take that on now, Mark, or should we table that one?
And one thing, I am not an expert. Trust me, there are a lot of smarter people in our industry out there. Anything that, Ryan, that we cannot answer, I will tell you, we will follow back up with any of the questions. This has been raised many times, especially on the hub. I think we can talk a little bit about it later, but I will. There's been a lot of concern with that. I definitely would have to talk to the governance part of the National Association when it comes to RPAC. An individual makes their own choices to invest. An individual makes their own choices to invest with certain members of Congress, members of the House of Representatives, their local, their state. So that is up to the member themselves. But when we see it, which we have, that's going to be a question we can try to talk to a little bit later, Ryan. If not, let me get some answers and I can get back to you, which you can get back to the ask.
Perfect. Appreciate that. And just for everyone's reference point, this is an active situation that we are continually talking to our friends at NAR and RPAC, not just the Alliance, but also the other trade organizations, and we're evaluating how we can all do better. So, Mark, I appreciate that. I'll toss it back to you to carry on.
Okay. I just I did pass through. We talked about the potential public trust issues. I mean, associations, depending who the governing body is that covers your association, whether it be local or state, of the Professional Standards Committee, when they are presented with certain possible violations and there is public trust issues, they do and have a responsibility to go to those other governing bodies, whether it be your licensing board, fair housing, banking industry when it comes to fraud. So that is the potential public trust issue lies back on the local or state governing bodies of the Professional Standards Committee. And you know, the last part of the preamble, the term, or not, this isn't the last part of the preamble, but the last thing I wanted to talk about during this explanation of 10.5 is this is in our preamble. The term Realtor has come to connote competency, fairness, and high integrity resulting from adherence to a lofty ideal or moral conduct in business relations. It's in our code. It's in our preamble prior to the code. So a lot of this is aspirational, raises us up to a higher bar of professionalism. What's next, Brian? Well, let's talk about the complaint process. I do believe when we talked earlier, some of the questions were, well, how do I file a complaint? Where do I go? What do I do? The ethics complaint, I'm going to stick on ethics. Of course, this is what 10.5 is, Article 10. When you deal with the last Article 17, that's arbitration. We're not going to, I can talk to you about arbitration, but that's a 7-hour class. But this is the ethics complaint process. So I do want you to know, depending where you're located, there are some state associations who handle all of the professional standards complaints, possible violations, and they have their own state committee. Just give you some examples. The West Virginia Association of Realtors is a state-run, even though we're a decently good-sized state geographically, we have 15 local boards, and our state association takes care of all the professional standards. I actually just got back 2 days ago in the northern part of the state in Wheeling. I did teach the state committee 7 hours of professional standards training. So every committee locally or statewide does have extra training. Friday, I will be in Delaware. Now, Delaware is a smaller state with 3 counties, but every county that's a local board, their local counties are their 3 local boards. Every local county hears and takes care of professional standards, violations, complaints, arbitration. So some states like Texas, okay, Texas has the Texas Association, which takes care of a lot of the littler boards, but a lot of the big boards, Houston, Austin, Dallas, Fort Worth, they hear that individually. So depending where you're located and where your primary membership is, that's where you need to find out, where do I file a complaint? Who do I call? So typically, if a complaint is going to be filed, then you call your local or state board for guidance. Again, we're not going to get into the informal option. They're going to ask you, do you want to voluntarily try to work this deal out with the respondent who you may be complaining on through what's called the ombudsman, which basically is a mediation. So there's no formal hearing. No one says I did or did not violate the code of ethics. The ombudsman basically primary role is communication and conciliation, not adjudication. That's, I mean, we could again go into a long discussion about that, but that's one option they're going to ask you. The option 2 would be the actual formal written complaint, and whatever board, state or local, will typically mail out a formal ethics complaint. The alleged respondent then does fill, or the alleged respondent's membership is in check to make sure that they're a member of that either local or state. And then you fill out, as far as the complainant, the paperwork. Now, I know a lot of you, because I do this all over, a lot of people say that's a lot of work. State and local associations, if you are, and I don't want to say confused, but yes, it's a tedious thing. It's not that long. It's not 15 pages, but if you need help filling out a possible complaint, the state or local association will give you someone to help guide you. Now, that person will be a third party that will not ever hear your complaint, ever be on a panel, but they will help you, but they won't help you determine, oh yeah, Mark did violate it. They're going to help you fill out the paperwork and submit it correctly. So state and local associations will have someone to help you. Once, hold on here. Go back. Once the state or local receives your complaint, then the state or local goes to their state or local committee, and then they either get a 3 to 5 to 7 member that sit on the professional standards committee 3, 5, or 7. I've seen 3 people on a grievance committee. I've seen 5 people on a grievance committee. I think I've even seen 10 people on a grievance committee, but it's formed and they hear the complaint, typically in a conference call or Zoom in-person format, and decide at this point if that complaint needs to proceed to an actual hearing. And the grievance committee's role, the basic issue is there a possible violation of the code? They don't say, yeah, Mark did violate the code. No. They look at the allegations from the complainant. If it was taken as true on their face of what you wrote as far as your synopsis of the complaint, is it possible that a violation of the Code of Ethics occurred? The grievance committee is kind of like in the judicial system, the grand jury. Okay, the grand jury doesn't say yes, guilty or not guilty or innocent, but does this move forward? So when you file a complaint, it does go to the grievance committee. The grievance committee then says, is this complaint a possible violations of one of the articles of the Code of Ethics? If it is then moved on to an actual hearing. A professional standards hearing panel is called to meet. This is typically, I don't want to say typically because of the world of Zoom. Some associations will do a Zoom hearing, some actually do it in person. But the function is actually conduct a full due process hearing, sworn testimony, witnesses, evidence. The hearing panel, again, is going to be comprised of members of that either local or state professional standards committee. Okay. If you are ever the complainant, the ones complaining, or if you're the respondent, this is something you bring testimony, you bring evidence, you can bring witnesses, bring your broker, bring your attorney. That is allowed in this hearing panel, this actual court kind of hearing. On the day of the hearing, each side is given opportunity to present their side of the case, cross-examinations of the party, and then once the hearing is over, after witnesses' testimony, the respondent and complainant are sent away, and then the panel, the either 3, 5, 7 hearing panel, then will deliberate and reach a decision. If the panel does find someone in violation of the Code of Ethics, they will then, as I said earlier, contact that association and say, okay, has Mark ever had a violation of the code? And what was it? And what article? And what was the discipline? So they know how to progressively discipline someone, or if it's someone a first time, but the possible discipline in an ethics hearing that, if found guilty, could be a letter of warning, letter of reprimand. You could be required to take more education. A fine not to exceed $15,000. Years ago, it was a fine not to exceed $5,000. During discussion one year, they raised it to 15. Someone wanted to raise it to 30. So if someone violates the code and is found guilty, they could be fined up to $15,000. They could be suspended for no less than 30 days, no more than 1 year. Now, when I say suspended, that's suspended from membership. Of course, your local, your state boards cannot take away someone's license. Only the state licensing authority could do that. So they could be suspended from membership. They could be expelled from membership from a period of at least 1 to 3 years. They could have their suspension or termination of MLS privileges taken away. And then, of course, administrative processing fee. And one of the things they could be is put on probation. Now, if they're put on probation, that means that it's kind of like parole. If you mess up, now we get to put some discipline against you. So that is the process, Ryan, in a nutshell. Again, I teach a 7-hour class, and so we really get into the weeds and drill down. I know we don't have 7 hours. So I just wanted to, before I show you some examples of what we've seen, I think now we could take some questions, or if anyone has any comments, Ryan, I'll let you moderate that.
All right, my friend, appreciate that. We do have questions, as I'm sure you can imagine. And Mark, are you okay if we make a PDF version of your deck available for the folks who are watching? Just because a lot of the questions that we're getting are about specific article amendments, and we're outlined in kind of that historical overview that you gave in the deck. Is that okay with you?
That is the only thing I do, which we'll talk afterwards, is the examples that I'm going to show. If we could delete those from the deck.
Yes.
Because
yep, absolutely.
These are true things that we have seen. Yep, disgusting.
We are fine with that, and we will pare it down to the facts and get that out for everyone. All right, so we got a lot going on here. Bear with me here. If you can recall back, Mark, a question is it correct that Article 34 remained in code for about 20 years?
I do. Now, I can't answer that perfectly, but I do believe it did. It was there for a while.
And just remind folks again, for those people who have been joining throughout the session, remind folks just on a high level what 34 says.
Actually, I'll try to get to it. Article 34 was, I can't find it. Article 34 in 1924.
And you know what, Mark, don't worry about it. We can,
yeah, Article 34 basically stated, give me 1 second because I have it right here.
Okay. And since you're in there, I have another question from folks about where they can get the book that you've referenced.
Okay, hang on 1 second. Let me do Article 34 first. Article 34 was in the code in 1924. It basically says a realtor shall not be instrumental in introducing into a neighborhood a character of property or occupancy, members of any race or nationality or any individual whose presence will clearly be detrimental to property values in that neighborhood. Okay, but I'm glad you asked me, because I will find out from NAR staff how long Article 34 was in there.
Fantastic. And we'll go ahead and we'll post all of these updates in the chat feature on this event on Facebook after we get the answers for everyone. Mark, another question. In terms of reporting, yeah, go ahead.
The book.
The book.
It is called The Code of Ethics and Arbitration Manual. I do know that it is available online at the website that you could download. You could also call and get that book mailed to you. I know a lot of local and state associations will order how many books they need for their committees.
Fabulous. Thank you for that. Let me read another one for you. In terms of reporting these concerns, are there structures in place beyond members reporting the things they see? An example that this individual is thinking of is that there is about a 400% increase in nationwide anti-Semitism that America is currently seeing, unfortunately. Does NAR do anything to proactively look for these offenses when issues come up in national culture issues?
As far as is a question, let me ask, does the National Association themselves look and police possible violations of something that would come up publicly like that's happening right now?
Correct. My understanding of the question, Mark, is there anything going on at NAR that you're aware of that is proactive instead of reactive in dealing with some of these more high-profile situations? You look at the anti-LGBTQ legislation sweeping the country, anti-Semitism, Islamophobia, any of that kind of stuff.
The National Association Professional Standards Committee Interpretations Committee is aware, and that's the little group that meets typically in Chicago the month before the mid-year meetings in DC and the national. Things are brought to them that others may not be aware about from the members, from CEOs, AEs, state and local. Then they will look at that and be proactive. As far as anything policing, that's us. We are our own police. We have to take care of our own profession, our own reputation, and that was part of that preamble. So if we do look at it as far as the interpretations and procedures committee, and Ryan, I think with the years I have been on there, things have come up pretty fast that we hit headstrong with, especially in 2020.
Yeah, absolutely. Thank you for stating that. Good question from someone out there, and I can attest to this personally because I can tell you, Mark, on the alliance level nationally, I've seen 4 or 5 cases now over the last 3 years where this has been the case. The question is, what do we do when our local or state associations do not take a complaint seriously?
Again, I'm a little startled by that question because they should. If you do have somebody that does not take a complaint seriously, I would reach out to NAR at the professional standards staff level and or the chair of the professional standards committee at that moment, or even vice chair, or I don't know if I'm opening myself up, but even myself. Okay. The Code of Ethics and Arbitration Manual states that boards must adopt the professional standards. All boards adopt having a professional standards committee, having a way, an avenue to stop the possible bad reputation and the bad players out there. Now, I will tell you that 95%, maybe 90% of all violations of the code are unknown, unknowingly. You violated unknowingly. But all local boards and state associations who handle professional standards have the responsibility to do it. And it's stated in that book. So if someone is saying, hey, I don't care, Ryan, I don't care what you have to say, I'm not going to even present it. You do have the National Association, you've got the chair of the professional standards you could reach out to. Heck, you could reach out to me.
That's helpful, Mark. And as you know, you and everyone else on the webinar watching us know that we're going through some culture change right now in the industry, and now is a time. If you see something, say something, as the mantra goes. Mark, talk a little bit, if you can, about retaliation, whistleblower protection, anything like that. There's a concern that is becoming more and more prevalent that if someone files a complaint, there's no protection in place for retaliation against them later. Can you talk about that?
And that is, again, one of the proactive things we're working with, not just Article 10. We have that has been brought up to the committee even 2-3 years ago about just a normal violation that you have charged. I don't want to say normal, maybe in Article 1, and then you get retaliation back from them. There is a certain safety mechanism for complainants that the state and locals have to provide, but it's not an anonymous. Now, I know that's what we talked about earlier. The Code of Ethics and the Professional Standards Committee feel that if someone files a complaint, the respondent should be able to, did we miss
Nope,
the screen?
That's our end. Don't worry about that.
Oh, okay. Okay. Should be able to face their accuser. Okay. Now, with that said, in the Code of Ethics and Arbitration Manual, the grievance committee could be the complainant. Okay, so the grievance committee could file a complaint if the grievance committee is made known of it by the local board or a board of directors of that association's professional standards administrators. Does that make sense?
Mm-hmm.
Okay. Now, I'm not saying, we don't inundate it, but every now and then, especially with the preponderance of the evidence, strong and convincing proof, especially when it is an Article 10, 10.5 with a picture, a post, a tweet, a screenshot.
Yep.
It is a much higher percentage that the board of directors and or the grievance committee would file that on their behalf.
And another question that we got was about filing anonymously. This also offers that solution on how to preserve some anonymity.
Correct. And here's the thing, and I'm not saying, but there are others out there. I know the anonymous, you're going to kill me on that. Being anonymous.
Anonymity.
Yeah. Reach out to people, other people in your local or state associations. I have gotten emails and texts and say, is this a possible violation? I don't want to do it. Can you do it? Okay. Of course, I have to be the member of whatever association. So there are people that you could reach out to that could possibly file on your behalf, especially if it is like I meant, or like I said, about the evidence strong, clear, and convincing.
Absolutely.
Okay.
Mark, we're wrapping up on time. We got maybe enough time for one question. I want to be respectful to everyone joining us. I got to tell you, there are some really fire questions here, some great questions. I think maybe one of the more relevant ones with timing, and take a stab at this. I understand that you're not part of staff and you can't necessarily speak for NAR in those capacities, but the question is, can you help me understand why association employees are not held to the code? What is the true complaint process in a situation like that?
The code of ethics falls under a realtor, being a member, being a realtor. No one else has to follow the code. Okay. We have non-members, non-realtors out there. Okay. They don't have to follow the code. So an employee who is not a realtor, not a member, doesn't have to follow the code, but you would think that the employer who they're employed under would have a harassment policy, a social media policy, a policy against the employee harassing realtors, hate speech epithets. That would then be taken up with that employer. Now, I know some of you will say, well, the employee is the employer and it's, they're the one doing it. Go to the next level. And depending on the severity of what would happen or what is happening, you could go to the governing body, the Fair Housing Administration, especially if it's a federal discrimination under the federal protected classes. So, trust me, there are people out there that want to help people. In West Virginia, and I'll wrap it up. I know time. We have 11 protected classes. We have 7 federal. As a realtor, we have 11 protected classes, 7 federal, 2 code of ethics, and then 2 state. You know what all 11 classes have in common? Ryan, they're human beings.
There you have it.
If people would understand that, we wouldn't have to have protected classes. So again, there's a lot of human beings. There's a lot of good people out there that will help you. Okay. Reach out to me. There's a lot of leadership at NAR, your local, your state, that will help you.
Mark Mansour, it is always a pleasure to be with you, my friend. The knowledge that you have in your head is intimidating sometimes. And I got to tell you, I'm feeling a little insuperior with all those gavels hanging on your wall behind you. But thank you for your time today. Just to remind folks, this education session and the series of education sessions before and going well through 2024 are brought to you by the Stop Hate in Real Estate Initiative. You can see our pledge is pretty simple, folks. If you haven't taken it, scoot on over to that website. You can go to .org or .com, stophateinrealestate.com, and take the pledge. Thank you so much for your time this afternoon with us. Please look for our next event, which we will start marketing and publicizing across social media. And until next time, be well. Thank you, my friend. I appreciate you.
Okay, I hope I did well.
You did great. You did great. We have some folks in the waiting room still watching, and there were some questions. A lot of thanks coming in, Mark, but there were some questions that I'm going to email you that we just didn't have time to get into, unfortunately.
Yeah, definitely, please email me. I am taking off tomorrow. I got to teach Delaware on Friday.